Then let's call the meeting of our staff meeting for February 23rd, 2026 to order. And welcome everybody. First item on our agenda is to review the agenda and ask if there are any additions or deletions from anyone. Do you have anything, MJ, you want to change on that? Or
I don't believe so. I don't believe so at this moment. We may need to move the executive session around a little bit.
okay.
Motion to accept the agenda as written.
Second.
Motion's been made and seconded to accept the agenda as written. Those in favor signify by saying aye.
Aye.
It's unanimous. We'll move on to our minutes from our last meeting of January 29th. Hopefully everybody's had a chance to take a look at them.
Yes.
Any suggested corrections for the minutes?
No, sir. Motion
Pretty
to
good.
accept the minutes as written.
Second.
Motion's made and seconded to accept the minutes for January 29th, 2026. As written, all in favor signify by saying aye.
Aye.
Any opposed? Very unanimous. Thank you. And I think I've got everybody's notes for the March schedule. I got Sam, I got yours this morning. And we'll try to get that out as soon as I can the next day or so. Do we have any changes, MJ, that you're aware of?
No, I think it just deviates from the norm due to town meeting day.
Right.
I think that is the only major
Looks like
change.
Thursday the 5th, we've got
Yes.
2 days of hearings.
So Thursday the 5th.
Yeah.
So both the 4th and the 5th schedules were held until today. I'm working with Emily on a couple of cases, and I'm working with Jill Martin on a few cases for the 4th. They're most likely, if it follows last month, we may need an overflow day again this month.
Okay.
I think we're going to be okay on the 5th. I'll tell you.
I had a feeling we would be.
Yeah, I
And
think
I think we're gonna be okay on the 4th as well, when I saw the initial list.
Great. Well, unless anyone has any questions or anything, I've got everyone's dates that there are conflicts on, and I'll put it together and get it out as soon as I can. You want to skip over the roundtable for now and go?
Well, the Department of Corrections isn't here yet, so I had stuck that there. I mean, we can go down to the legislative update.
Yeah, I was going to say, how
if you'd
about doing 559?
like. Okay, let me pull it up real quick.
Friends from the Prisoners' Rights Office might be interested in it too.
Yes, we were.
Yeah, it sounds like a positive step forward. Yeah.
Just give me a couple of minutes. That's the one thing I did not pull up this morning. Or last night. Okay, Wednesday, last Wednesday. All right, I'll share my screen just so I can put it up on the screen for everybody, because I did not print it off. So as you all, or as the board is aware, H559 was introduced at the beginning of the session. It is an act relating to the parole board. It is currently in draft 1.1. Draft 1.2, I believe it's going to be, is slated to come out today or tomorrow. I've been invited back to speak tomorrow afternoon. Some more. So the main changes since the last review is that at least annually, in collaboration with myself and the chair of the board, the Commissioner of Corrections is charged with providing training or helping to lead to provide resources for training around criminogenic behavior, mental health disorders, substance use treatment, trauma-informed work with victims of crimes and serious crime rehabilitation. It may not be DOC doing the training, but they're going to collaborate with us to get trainers to provide that training to the board. The second change was around changing the boards from 5 members to 7 members. Right now, we are 7 members. We're 5 members and 2 alternates. We treat all board members as equals. So this is just modernizing it to our actual process.
There was some concern that by doing that, it may change what the quorum is supposed
Yep.
to be, and they were going to address that.
Yep, they didn't change it. They're still leaving it as a quorum of 3. My thoughts of why I recommended changing it away from the old practice is I was afraid if a new chair came in that they may want to look at the board as 5 members and the alternates would be truly alternates. So, because you don't know in the future what might happen. Some more language that was added is that prior to appointing a member, the governor shall consult with the parole board director and the chair of the board. What that consultation looks like, they didn't want to go into that. It could be we are told the day before, but at least we're consulted with potentially. Also, some language around board members. It previously said members. The governor shall appoint members persons who have knowledge of and experience in correctional treatment, crime prevention, and human relations. This is being changed to criminogenic behavior, mental health treatment, substance use disorder, or serious crime rehabilitation. And also, they added language around that the governor shall give consideration to the balance of different knowledge and experience on the board as well. Been a lot of talk about pay, but no action on pay of board members.
Yeah,
Yeah,
yeah, right.
as we would expect.
Yeah. I was really worried about that one.
And then there's been another section that says at least annually, each member of the board shall attend trainings designated by the parole board director in collaboration with the chair of the board.
Only if they pay me.
Hey, I pay you per diem.
I'm just kidding.
And then at the last part is around the director, adding a section that says the director shall be responsible for the overall function of the board, ensuring legal compliance, developing and implementing all policies and procedures of the board, and developing and providing training to the board in collaboration with the commissioner, which is the commissioner of corrections and the chair of the parole board. The other 2 topics that are not in here, which should be in 1.2, is around legal counsel for the board. Moving away from, the goal is to move away from an assistant attorney general, specifically in the DOC litigation unit as our attorney. I am going to be starting to work with the attorney general's office around looking at attorneys that they already contract with for other quasi-judicial boards to utilize $25,000 that we have currently for FY26 to start getting someone on board to initially develop some training, especially around due process and violations, rules of evidence, so forth. And then also on top of that, start to help a little bit with our policy manual, especially around our violation process, to try to clean it up a little bit, make it a little bit more streamlined for everyone. And in the
money would be just for like billable hours from.
Yes, yep. And then in the meantime, the assistant attorney generals would still litigate our cases for us. Then there's talk around FY27, because that $25,000 that we've had was taken out in FY27. So there's talk about whether or not this committee is going to look to have it put back in or not. And there's also been talk around changing the 25 to 50. So I don't know. That'll be another topic for tomorrow. And then the other piece was around our budget. making some session law around ensuring that DOC, because our budget lives in the DOC budget, that DOC and the Human Services Secretary's office ensure that they consult with us around our budgetary needs when it's budget season. So those,
Sense.
so that's
We
the,
have a long history with them if they just do what they want with our
Yeah.
budget.
yeah,
Oh, no.
well, I kind of spoke out and
Yes,
got
you did.
a little
which is good.
change coming, but we'll see.
I was in the Ops on Friday testifying and there's no, when I made a small comment about some $10,000 for something, they looked like I was asking them to give up a kidney.
Yeah.
I don't see much money this year.
It's tough budget time right now, so if we can get the 25, use the 25,000 we currently have towards some legal counsel, get that started, that way we can start to have some billable hours so we can look to see what our need is, and then we can come back for FY28 and present something. That's our overall goal. Take what we've got and use it before it goes away, because it was going to use as their offsets of costs.
Good job with the bill.
Yeah, it looks good.
It's been really helpful to have institutions looking at us favorably and inviting MJ in multiple times to help with crafting the language.
I'm
So
really happy to see the change in the views of really wanting the mental health and the substance use
Yeah.
focus. I mean, of course, you know, in the world that I work in, I think that's really great. MJ, what do you think that shift has come from?
That change, that came
Where
from
they-
me.
Good. Okay. I didn't because they like when they
There's nobody there initiating it.
So a lot of this, so honestly, I drafted 99% of this change language.
okay.
The top part around the Commissioner of Corrections helping with training, that came elsewhere. Todd Delos from the Attorney General's office helped initiate, because Lori Fisher, when she was our attorney, was very vocal about the board becoming more independent, getting our own counsel and so forth. So she had really pushed to the Attorney General when she was under that realm to get this moving. And they took it on this year, helped me get it to Representative Emmons. She latched on and has really understands the needs. The whole committee is really understanding the needs of the board.
Mhm. Yeah.
They
I
just
just
gotta
think
get
that's great.
Yes.
That's
And-
because that
and
is
I-
a huge piece of everything that we see in hearings a lot of times, the substance use and the mental health. But I mean, like I've said, I'm more than happy to do whatever I can in terms of training. Whatever you
Thank
want
you.
me to provide, I can do.
Great.
Like, and just present something to give us an agenda item one of these months, Katie, and we'll go with it.
Well, I mean, I think it's so interesting because like I've given tons of trainings on, you know, major mental health and substance use and trauma informed. So it's really for me, it's sort of like what is the main what do people want to know about? You know, what is, because I love giving trainings. I did it for years. So I just need to know like
Great.
what people are really wanting to hear the most, you know.
Well, and I would divert, so as we have this, if you don't mind us keeping to go down this, I would say I would divert to everyone, all the board members, to
Mhm.
really think
Mhm.
about what are the knowledge areas and what are the areas that you think would be very helpful. And we can explore some of those.
Why don't we have a chat too, Katie, and we can talk about some different aspects of that and what.
Yeah.
Yeah, and even, you know,
We'll see.
tailoring on time and, you know,
Yeah.
what time frame, what, you know.
Mhm.
You know, I love putting stuff like that together. So
Great.
Because we're always looking for I'm always looking for agenda items to help, so I don't have to bore you all with the same topics month to month.
So, thank you.
Yes.
Anybody else, any comments or thoughts on 559?
Good job.
I have a feeling the committee I don't know what their timeframes are, but being that town meetings next week, I have a feeling they're gonna try to vote it out of
I
committee
think
this
they
week.
have to.
They
I
have
think
to.
they have to too.
Before
They were
crossover,
voting
right,
through the
yeah.
committee on last Friday, so.
Yep, so I think we're scheduled from 3 to 4:30 tomorrow for the next draft.
What is, and this is just a knowledge thing. I'm kind of
Mhm.
new to that. What do you mean vote it out of committee? What does that mean?
So the committee has to agree on the language of the bill. So they would vote, the whole committee would vote whether they support it or not. If it's in favor to support, they would vote it, and then it would go to the entire house for the house to
Okay.
review and vote on.
So it
So
becomes an
that's how
agenda
it gets
item.
moved.
It
That's
gets-
how it gets moved
If it
into.
comes out of committee, then the speaker will put it on as an agenda for the whole house to consider. If the house votes to approve it, then it gets moved over to the Senate. They'll have it in a committee there and it'll get changed there and then come back to the house. And then if it doesn't get agreed on, they'll have a conference committee and it'll either die or get worked out and then eventually, hopefully, get to the governor.
But if it doesn't,
But all the conversations are live streamed, so you can go on and listen to it as they're talking about it, which is nice.
Yeah.
Or
Mm.
or there's
Even
YouTube
afterwards.
channels, you can watch it after the
Yeah.
fact.
but it has to be out of committee for a town meeting day or stays
Yeah.
on the wall, as they say.
Yeah.
It doesn't get out
This
of
is
the,
the second
Doesn't
year, it
move.
would die.
it would die.
Being that it's
If
on
it
the
doesn't get
Tuesday
out
this
before
time,
town meeting day?
It's,
Okay.
there
There are
hasn't been
exceptions,
one
but-
committee member that's not in support of this, so I think it will come out this
Yeah.
week. And also, when it gets to the Senate, I believe I know there'll be support from at least one senator, because there's even more robust bills sitting in Senate Judiciary
Yeah.
that would make the board full-time.
Mhm.
All right. Shall we drop back to out-of-state pending charges? And-
I would like to also wait for Jordan if we could, because he's the director of classification and he oversees Morgan Rogers. I think it would be
Okay.
helpful for him to be part of that.
All right.
I'm just gonna message him and see.
Sounds good.
So I would,
While we're waiting, do you guys have anything you want to throw out to us for consideration or discussion or?
I mean, I like everything I'm hearing. I think it would be great if the board had independent legal counsel. It would be great for us to have someone to go to that's not corrections, because it feels a little wonky going to corrections about a case we're litigating, you know? So I'm super excited about that. I don't really have anything systemic. I feel like you guys are actually touching on the systemic things that I might think about, so that's great.
Yeah, obviously one of the bigger concerns for us is violation hearings now with DOC's changing their policy. And we sat in on a conversation with MJ and I on that. So we've started brainstorming a bit how we're going to handle them.
What, changing the policy
Well,
about,
now that the attorney generals are not gonna be
Right,
coming
right.
even to condition one,
right,
and so
right.
just,
And they won't be.
What it's gonna
subpoenaing
look
any
like.
witnesses. So their evidence is their evidence.
Wait, they won't be serving the subpoenas, or they're not
They're
gonna,
not gonna bring in any witnesses.
sounds like a conversation that needs to continue with correct, right? Like, I don't understand how that would work.
and they're on their way in a
Okay.
couple of minutes. Lori and Jordan are on their
Okay.
way.
Were they gonna talk to that issue at all, or no, they did last month?
They
but-
did last month, I
Yeah,
don't
so I
know.
don't think that's gonna,
You
but
went to,
they're changing how they handle those dramatically, or have changed
Mhm,
1st of February.
mhm.
So it kind of leaves us in a situation where we've got to determine what evidence is suitable. And Marco, we had a case not too long ago. Fortunately, the courts had acted on it and gave us some leeway there, but
Right, right. I didn't realize, I knew about the AG's not coming. I didn't realize about the deciding not to subpoena witnesses. I don't really understand how that could even work.
they're essentially saying that they're treating them as they do with probation cases, and they just present the information and
But they have to
Let
bring
the courts
witnesses
decide.
for probation cases also. Like there's some really strong Supreme Court case law on
Yeah.
the right to confront in probation hearings. So like,
but
I
it's
don't-
the state's attorney's office that's the prosecutor that deals with it.
right. Oh, I
We
see.
don't have that.
Oh, I see.
Yeah.
Hmm.
Yeah.
So along that line, if you guys want confrontation with somebody and that person isn't there and we have to subpoena them, are you going to tell us who you want confrontation with?
Well, this is
No.
the first I'm learning of the
Yeah.
policy shift, so I'd have to think
Well, the
that.
problem is we can subpoena them, but we don't have the budget or the money to do any of that. It's never been a part of our process.
Right.
It's going to be an awkward situation, and we're going to have to act on the evidence that's there.
Because usually parties subpoena their own witnesses, like,
Yeah,
Right.
that's how it works in the court system. Like
Yeah.
the courts don't actually subpoena,
right.
they make the form, but they don't.
Yeah.
We'll have to talk this
Yeah,
over,
and I think there are some pretty serious ethical issues for us as defense attorneys, subpoenaing witnesses who could potentially not be on our client's side and having to disclose what our client has told us. And so that's why my instinct was no.
Yeah.
Because it's an adversary process,
Of course
parole
it is, yeah.
violations, and so,
we get that.
yeah.
Ultimately, we sit and put them on postponement schedules.
Yeah.
But if they're incarcerated, that could take a long time before the court acts on it, and how you deal with that is another issue.
You can't continue forever, especially if the person is pending misdemeanors, because they'll sit, their court case will sit forever. That's really tricky. I was not aware. I know that
Yes,
when
it
we
is.
did that schedule last week, there weren't witnesses for
Right.
those two hearings, and one you continued and the other one you took no action, which made sense given the context of those two cases.
Right.
But the first one that we continued can't sit forever.
Right.
Right.
So
Right.
it's tricky.
Yeah.
And that's where I had raised to our concern that if the person is held without bail in the court case, it might not be as devastating an impact, but if they are not held by the court case, and so it's only the parole case holding them, that's where I think we run
And so
into
you get
trouble.
the argument from the other side a lot of times that the reason the court's releasing them is because they know the parole board's holding it, kind of thing, and that whole game that gets tossed around.
Yeah, I think it's usually the opposite. What I hear from defense attorneys is there's no point in even considering bail because there's a parole hold. Like I hear the other, like you got to get, like the court won't
Yeah.
do anything till you get the parole hold lifted. So I think generally though, when judges, like we always educate attorneys, like when judges set bail, like then when the parole board, if the parole board releases the person, they go. And often the court will be like, okay, I want the person to go into treatment, understanding that the
Right.
board would want the same thing if they were to release the person. So, that's really
Yeah.
tricky.
It is tricky.
That is really tricky. I have to think about this.
It kind of puts us in the middle in most cases.
Mhm.
It really puts you guys in a really tough spot. It's almost as though the adversary system you depend upon isn't working, right? Like they're supposed to bring the witnesses, we bring up, there's this whole process that
Yeah.
you need to rely on to make a decision. And if this side isn't doing what they need to, then how do you?
Well, and my other suggestion was maybe in misdemeanor cases, POs should wait to file a violation until there's a conviction. Because then, if it's
Right, but they're, but they're not only are they not doing that, their new policy is if there's a pending charge, the person has to be held, even if
Right.
it's a misdemeanor.
Yeah.
So
Right.
they're on the opposite side.
right, but that would be that would be a way to
Yeah, that'd be great,
skirt the issue.
but DOC is now,
Good luck with that one.
yeah, right? Like,
That makes sense.
but I don't see them doing that either. Holy crow.
You're learning a lot today. aren't you?
Yeah, well, this is about this because that's a tricky issue.
Wayne, are you thinking about this?
Oh, I'm thinking, but I guess I'm staying kind of mute.
It's not like you.
Well, it still goes back to what I've harped on for years. Is I truly believe
That's,
the Department of Corrections needs to designate a quote unquote prosecutor in each district office or each section who has some working knowledge of how to prepare a case and bring it to trial or hearing. There is never any discovery done on any of these cases. I sit and I review them, and I mean, I take myself back 30 years when that's all I did was discovery for John Rocray in the state's attorney's office. And that's where I learned the insides and outs. But I sit and review these cases and, well, we're going to need that video. Here's a witness, here's a witness, here's a witness. And we get nothing. And I get so frustrated when these parole officers come and they just throw a piece of paper out and say, well, this is it. No, it's not.
Right.
I think that's an
So-
interesting idea, Wayne. Yeah, because in New Hampshire, there are police prosecutors who actually prosecute in district court.
I've been
And that's
harping
kind of
on
what
this.
you're
I said,
advocating for.
I said, if you follow New Hampshire's model of designating and training one person and let your POs bring their violations to them, they can do the discovery on it, they can prepare the hearing, and we could all move forward a lot easier, but
Right.
deaf ears.
Yeah. Doesn't look like that's going to happen.
no,
And it wouldn't be that hard because they could work with the prosecutor in a criminal case, right? Like they're collecting the discovery, so it wouldn't be that onerous.
Unfortunately, though, it sounds like they have made their decision. This is how.
Well, and they are on their way.
Yeah.
So if we'd like to include them further in this conversation too. Just wanted to give you guys all the updates. I did get the update that they are on their way.
Sure.
Wait a minute. It goes back to, 4 years ago when we used to ask questions and then we decided that that's not our role. I've come like full circle now when I see a violation that I've reviewed. I feel like the first question I want to ask the PO is, why are you here? Because nothing's going to happen. Okay, now you asked, Steve, you got it.
Nice, that's going deep.
He was awake, all right.
So, we have some good conversations here. Right?
I'll bet you do, right? Yeah.
Years ago, there was a plan to do that,
Yeah.
but they don't have, there's so much influx now there.
Yeah.
Luckily, they have somebody who can cover the boards, that's knows something.
Well, we'll work it out.
I guess.
I mean,
Yeah.
they do have some talented POs that we've seen that know what
Yeah.
they're doing. And if they just take advantage of those people, designate them as the prosecutor, give them a little more training, and I think this whole system would work so much more efficiently.
Mhm. Some other offices used to have different like designations for the POs. Like, do you remember that PO in Brattleboro who had the mental health caseload? He was a really heavy guy, and I think he passed away, but he was the one that handled just generally clients with mental health issues, and he was amazing.
He passed away.
I think he passed. He was very heavy man from Brattleboro.
It's not Rick Bates.
Is it Michael?
It's no,
Anyway, he was wonderful. He was so good with the individuals that had mental health issues. Like there used to be a little bit of like striation within the offices.
Mhm.
I guess there still is around domestic violence, but I don't know.
They choose to do it on their own.
Yeah.
when I took over in Rutland, I stopped that because he had like Joan Eckley, remember Joan?
Mhm.
She'd old
Yeah,
sex offenders.
yeah.
So I came on as the boss and I said, nobody else in the office knew how to do any of this
Right.
sex offender paperwork.
Right,
I said, wait a
right,
minute here.
Yeah.
right.
We can't operate that. So she'd get the primary, but we would also have,
Yeah.
she'd have some, but everybody would have some because they had to know how to do the work.
Right.
Perfect.
Are you Jordan?
I am Jordan.
Hi, Don Seaver
Hi,
from
Don.
Prisoners
Nice to
Right.
meet
We've
you.
never met.
I'm
I've-
Emily Wang.
Emily.
I've
nice
seen
to
your
meet
name
you.
a bunch of times.
Marco.
Marco. Jordan.
Hi, Lori.
Hello,
Good, how are you?
Thank you.
Good.
Hi.
Jordan?
We should
Yes,
probably
yes.
do a little roundtable and screen.
So we have three of our board members who are attending by teams. You want to start off, MJ?
Sure. Good morning. You all know who I am. Sam will be right back. So
I think you know who I am. I'm giving.
I'm Pat.
Dean George.
I'm
Marco.
Katie. Sorry,
Sorry.
Go ahead, Katie.
Katie Aiken.
Angela Sheeklin.
And Wayne Dangley.
Samantha
Greetings.
Drake.
Meet everybody.
This is Jordan Pasha. He's the director of classification. I don't know if I missed any of your title because I know your title has changed over the years.
You nailed it.
They simplified it finally.
And Lori.
And everyone knows Lori.
And you all know the Prisoners' Rights Office attorneys?
Yes.
Okay. Great. So we were just having sort of a discussion around our violation concerns and how we're addressing them with the new procedure from the Department of Corrections. I know that's not what you're here to talk about, Jordan, so.
Do you want to just dive right in, MJ, or?
Yeah, go for it.
Okay. So MJ asked me to be here to talk a little bit about the department's RSN designation, and risk containment classification. So I don't know if folks want to start with questions, or I can kind of give a brief overview of both of those things and how they differ.
I think an overview would
Yeah, that would be
great to
sure.
start with.
Yeah, okay, that's easy. So let's start with RSN. RSN stands for Release Sensitive Notification. So what an RSN designation does is it allows the department to kind of slow down the release process and take a really hard and close look at what are the risks that this individual poses to the general public, to their victims, and what can the department do upon release to mitigate those risks and try to ensure a successful reentry to the community. So the release process for somebody who's designated as RSN is a little bit different, and it's going to be different under any release mechanism. So whether that be probation, parole, or community supervision furlough, an RSN designation applies a little bit of limited discretion on behalf of the department to that case. So whenever we're reviewing somebody or considering somebody for release when they're designated as RSN, that release request has to come before the Central Case Staffing Committee. The Central Case Staffing Committee will review the case, will determine if it's appropriate for release. If we determine that it's not, we're sending it back to the individual with recommendations on what they need to do to be release eligible. If we do say that this is an appropriate release plan, it moves forward and goes to the executive team. Once we say, yes, this release is appropriate to move forward, the field and the facility now have to do a couple things. So one, they have to write an RSN executive summary. An RSN executive summary is a fairly detailed overview of the entire case. So we're looking at field supervision history, facility supervision history, victim contact, any victim concerns that exist, a general overview of the entire case. That goes up to the executive team, which is Commissioner Murad, Deputy Commissioner Calver, Chief Denton, and Ms. Fisher. And they will make the final determination on if that release is going to be approved. And again, if they say this release is not approved, it comes back with recommendations for improvement. At the same time, the field is doing a law enforcement notification, which is just a notification that goes out to local law enforcement based on where the individual plans to be living. If we have information that that individual may be going out of state, we'll send it to the state police of that state. But it just lets law enforcement know, hey, this person's coming out. Here's their charges. Here's where they're going to be staying. Just some general information for law enforcement to be aware of. So that is kind of RSN in a nutshell. Are there any questions about RSN before I dive into risk containment? Because I don't want
Did
to.
that notification also go out to victims at the same time?
Victims get a separate notification.
Would they be notified that
they
this
will.
person is RSN designated?
They will be told that, yeah. Yeah, victim services does that notification, and also the PO and the caseworker.
And occasionally we'll get a case that comes before us where RSN has not been determined yet. And it's probably, as you described, it's gone back to the committee or the office to fill in the other details. Is there a timeline that typically has to be met
To apply an RSN designation? No, we can apply an RSN designation at any point during an individual's supervision history. We generally do it once an individual has been fully sentenced because we want to consider the totality of the case, right? And if they're still detained on those charges, they're not yet convicted. That doesn't really speak to the totality of the case. Those charges could get dropped, they could get amended. So we're not really entirely sure what we're working with detainer cases. So we tend not to apply either risk containment or RSN designation to those cases. Once an RSN case comes before us and we determine that release is appropriate based on what we have in front of us, that starts a 55-day timeline. So 45 days for the executive review and approval, and then an additional 10 days for the law enforcement notification to be distributed. So a potential maximum of 55 days.
And that's after the central case staffing?
That's from the time that the central case staffing
Okay.
committee says, yes, this release plan is appropriate for further
Okay.
review.
So the central case staffing reports, which get included in our parole summaries, which is great information for us.
Sure.
Does that include the executive summary? I mean, it sounds like some of those details are in there in most of them.
Yeah, most of what's in the executive summary is going to be in the case staffing summary. The executive summary itself is not included with the case staffing request document that you folks generally see. But the RSN executive summary, either at the time of the staffing, if the field and facility have completed it, or shortly after the staffing, will be uploaded to that staffing request in the document section. I'm not sure if you folks have access to that, but it would be good.
Okay, that's good to know, because I think we get the case staffing from staff, but we don't always get that document that's added.
Yeah, it should be uploaded to the document section.
And is there a timeline when these cases are reviewed again, or does it depend on the sentence? Or a lot of times that question will come up and we don't know what the expected next review might be for someone who has been designated.
Yeah, so typically,
Permanent.
well, an RSN designation is more or less permanent. There's no real criteria within the directive to remove an RSN designation, and I'm not sure that we would want to remove an RSN designation. A lot of the factors that contribute to an RSN designation are static. We don't expect those factors to change. The harm that's done to a victim is done. The crime that's committed is committed. Their facility behavior has already been substantiated. It's already there. So there's no real criteria to remove an RSN designation.
So there are RSN cases that come to us where there is no release planning, and then there are RSN cases that come to us where release planning is in process.
Mhm.
What makes the determination for that?
Well, I mean, we can't necessarily stop an incarcerated individual from release planning. We can certainly not review that plan if we don't feel that they're ready or the department's not willing to release them at this time. So I'm not really sure if that answers your question.
Well, no, I'm thinking of the ones that are being prepared and endorsed by the Department of Corrections. So
Yeah.
they're coming before us with release planning that they have worked on with them
Right.
and are in support of it.
Yeah. So typically by the time the Central Case Staffing Committee is reviewing an RSN case for release, that release plan is already done. And if it's not done, we're going to say there's no release plan here. There's no decision to make, and we're going to send it back.
Can I ask a question? Sorry. What training is the field getting? Because I can think of a case specifically where the executive committee said it's not a solid release plan and kicked it back, but then both the caseworker and the PO came to us and said they have no idea why it was denied, that he's gone above and beyond what he needs to do. So what training is the field getting on these?
On creating a release plan?
On all of it? Because I feel like sometimes we see them and we're being told we don't know why it was denied. He had a solid release plan. He's good to go. But then there's no release plan because it was denied. Does that make sense? Sorry.
It does make sense. And sometimes a plan that the field the PO or the caseworker feel is an appropriate plan is not an appropriate plan. Sometimes it doesn't appropriately address risk mitigation. It doesn't appropriately address what the individual is going to do differently during this release that they haven't done before. We see these release plans with these really great wrap services and access to mental health and access to MAT medication and plans for employment and plans for education. And we look at this plan and we say, okay, your plan 2 years ago had all the same stuff and you still recidivated. So what's going to be different?
Okay.
Does that answer?
Yeah, kind of. I think I just struggle because sometimes we see them and everybody's like, we don't know why they were denied, but here they are, they're ready to go.
Right.
And so for us, it's two completely different things, both coming to us from the department. So I definitely struggle with that.
Yeah, for
Well,
sure.
it should never be. You should never get two different opinions from the department. You should get one opinion. So that's on us to align that. So anytime you guys see that, MJ's pretty good about alerting
Yep.
us to that.
Okay.
But a PO and caseworker that come in should all be unified on that. So that's an us problem.
Okay.
And they do fully well know why it was denied. So they just don't want to throw the execs under the bus about it, to be honest with you.
Thank you.
I think what's really uncomfortable for a lot of field and facility folks is that like they're used to and they're trained and they're told their job is to mitigate these risks, right? And they're doing all this work to mitigate these risks. They're getting all these things in place. And then they come before the Central Case Staffing Committee and we say no. And one of the things that the committee has been trying to reinforce with those folks is that when we say no, in most cases recently, when we say no, it's not a reflection of the work that the PO is doing or the caseworker is doing. It's a reflection of the work that the incarcerated individual has not done.
Okay.
Show us how you plan to mitigate your risk. The department has done its part. We've put you through services. We've given you these wrap services upon your release. We have referred you to inpatient treatment here, 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 and here, and it has failed to mitigate your risk and you have failed to take advantage of those opportunities. So what are you going to do different? We're putting a little bit of the onus back on the individual.
I have a long history with RSN. I remember when it came out and it's changed dramatically from what it was originally, which I can accept. What I can't accept is the ambiguousness of it. So you ask, somebody has to show positive behavior. What is that? I asked the caseworker, the PO. I get, the guy had no DRs. He was doing had a facility job, doing what he was supposed to be doing. But he had to exhibit positive behavior.
Mhm.
How long will that take? We don't know. It has to do more programs. This, I think, a case just recently. He had done every program he's supposed to be doing. RSN used to be for people who are really, the worst of the worst. Now it's become a much different thing. And you could tell the POs and the caseworkers are uncomfortable with it. They don't support it a lot of the times. You could tell. If you're going to do this, you need to have some time guide. So what is appropriate behavior? I don't get an answer. I take the case staffing. I will read things out the case staffing, the PO and the caseworker. Can you tell me what these are? We don't know. To tell a guy who has everything in place, ready to go out the door, and then say, oh yes, now you're RSN, you can't, because you have to show appropriate behavior. And he goes, what am I supposed to do? So I think you need to, if you're going to throw an RSN designation on somebody, it can't be ambiguous. It should be a timeline. So this is what we're looking for. To say we want you to work on your plan, okay, I can accept that. But what is supposed to be in the plan? What you said about, more programs, we've done it, you screwed up every time. But what is going to be different? Those things I can understand. But to say you need to be a good boy in jail, and what Dean always says is they're not Boy Scouts. I can accept that. But people need to know what the guidelines are. What's supposed to be happening? What am I supposed to do? What do I need? So I got to be in jail for a year. In that year, what am I supposed to do? I can remember the RSNs back in the day were the people who were we can talk about really bad cases, had a lot of publicity and had a lot of heinous crimes. Those were the RS. I see people that would never been RSN now and I don't understand why they're RSN. But I think to have a guideline I can see, when I ask a PO or caseworker, what does this mean? They can tell me.
Will anyone can you get a positive parole recommendation with RSN designation?
Could you? Yeah.
Because we're just seeing more and more that we're not, and I don't know, and they come to us and say, what do I do? And I guess that goes to Tom's question. We don't know what to tell them. Because if RSN is permanent, they're never going to not be RSN. So I guess I'm wondering what those people, not risk contained, but the RSN people, what they're supposed to be doing to get a positive parole recommendation. If it says in there, because this person's RSN, we are not recommending release. What do they do? Like, what's the answer for us to tell them?
Regarding a parole recommendation?
Yeah. What do I tell them? Like, this is what they want you to do. Cause you just said you're always going to be RSN. So once I hear someone say, we can't give a positive recommendation because they're RSN, and then they call prisoners' rights and say, what should I do now? What's the answer to that?
That's a good question. I mean, other than what we've already messaged broadly, which is maintaining compliance with facility rules. If they've completed risk intervention services, demonstrating that the skills that they've learned in risk intervention services, they can apply to an incarcerated setting, which would be an indicator that those skills have been learned and will be utilized upon release to the community. They can maintain facility employment. They can engage with education, whether that be high school or CCV classes. There are free risk mitigation programs on the tablet that they can do, and they can earn certifications that way. They can earn vocational certifications through that tablet, as well as through on-site training at the facility. See what else. I mean, so doing those things and maintaining that behavior will ultimately lower their risk level. Eventually their points will reduce if they're not already minimum custody. So those are a couple of ways that they can demonstrate that compliance and that kind of positive pro-social behavior that we're looking for to indicate readiness.
Okay, but they would still be RSN even if they did those
Correct.
things.
Yeah.
And how long? I mean, if somebody does everything you just said, how long? Is it a year, 2 years? Is it an interrupt sentence? I mean, I don't understand if somebody who has been doing this right along is still RSN, and I don't see an answer for when they would be qualified for either a positive recommendation or at least do some release planning. I mean, I don't hear an answer.
Well, my answer is, if we're denying an RSN release because there's public safety or victim concerns,
I understand that.
Our general answer has been we'll review it in a year.
Yep.
So we review it in that year. And if they have maintained that facility compliance, if they've maintained the rules, then I can't speak for the entire committee. I can only speak for myself. I'm the only one here, but I would be willing to take a closer look at that release approval.
Okay, so you're saying if they do everything they're supposed to be doing, what you just said, it'd be a year review.
That has been our general answer: is release is not approved at this time. We'll review in a year.
Does the RSN designation replace what used to be the level C designation?
No, that's risk containment. Risk containment replaced level C.
Okay, we're going to talk about that.
We haven't even dove into it yet.
Once in a while, we will get someone in front of us who has been incarcerated for a number of years. And all of a sudden, their RSN designation. And I guess I don't understand after, so many years, why all of a sudden, is it because of their facility behavior that all of a sudden they're being designated as RSN?
It could be. It could just be that they're nearing release. So we've taken a look at that case and said, what release considerations do we need to make here? And then that's when RSN is flagged as possibly appropriate.
Okay. And sometimes they say, now I've got to do programming for a year. But they didn't have to do programming before.
Well, somebody who's RSN wouldn't automatically have to program.
Okay.
Programming determinations are made on a case-by-case basis, but it goes back to the same thing that I just said, where we're looking at release considerations. Risk intervention services is a pre-release service. It's designed to be delivered in a certain proximity to an expected release to achieve maximum efficacy. So that might be why that decision was made at that time, because we look at that case and we say, okay, this person is releasing within the next 3 to 5 years. Do we want to look at pre-release services, and would those be appropriate?
Okay.
If issues come up during the interview process with the board or anything like that, where there's questions, does your committee endorse having a chance to review those questions to get a response?
Yeah, I mean, questions from the incarcerated individual themselves.
Well, no, not necessarily that don't get answered in the hearing, for example. There's no understanding clearly one way or the other. And so we hold off on making a decision, thinking maybe there's some other issues that we need to find out about first.
Yeah. I guess, am I understanding that you're asking if the board could reach out to the committee
Yeah.
to answer those questions? I'm going to punt that one to general counsel.
Yeah, well, these folks sitting right here at the end of the table ask us all the questions all the time. If something comes out of your function that doesn't make sense to them in advance of or after plans have been presented. So, but those questions certainly come to my office and then we would get you the answer for that, for sure. And the other piece too is that, and again, the prisoners' rights team has been very effective on this lately, is that the individuals get to submit any sort of, and we haven't gone through containment yet, but they get to submit any information that they want the committee to consider.
Mhm.
So sometimes you're getting information that has never been put forth in front of the committee for them to consider.
Right, right.
So it looks like it's a surprise to everyone. We haven't even heard it yet.
Yeah, and that's
So
what I'm,
that might be appropriate.
and that's what I'm thinking about. And prisoners' rights aren't at these hearings anyway, for the most part. It's just us and your POs and caseworkers, which, you know, when we reach that point in the decision-making process, sometimes there's questions about, well, is this available or is that available? Or is this being worked on or part of the process for this individual or not? And no one has an answer. Before we make a decision one way or the other, it would be helpful to know if that is the case. And then we can move forward from there.
Sure. And I mean, again, I sounds like a couple things we need to talk to Field about in general, but I think those questions can be put back on the PO that's there to get you an answer, and they'll come to me and we'll get you your answer
Okay.
anyway. Or you can come to me directly and we can get you the answer on that as well.
Okay, thank you. Anyone else on RSN?
Okay. Risk containment.
Risk containment.
So risk containment is a little bit different. Whereas RSN is a designation, risk containment is a classification. So that means, in very plainly put, it's going to have a few more implications than a designation is going to have. So what a risk containment classification is essentially saying is that the department has compiled credible evidence within the record, which indicates that the individual is or may present an unmitigatable risk of harm to the community if they were to be released. So these reviews and these classifications are a lot more intensive, and I'll just walk through the process a little bit. So a PO or a caseworker will submit a case staffing request in consideration of a risk containment classification. And in that, they're going to put kind of a brief overview of facility history, field supervision history, program history, details from charges, kind of all the things that we talked about with an RSN designation. Similar things will be within the risk containment classification request. We will take a look at that. The Central Case Staffing Committee will look at that request and will determine, does this warrant further review? Does it meet the initial criteria for risk containment review, which are conviction of a felony, conviction of a listed offense, conviction of a sex offense, all as defined by state law. If it meets that criteria, and there's some indication in the case, like a pattern of reoffense history or continuation of risk factors while incarcerated, we're going to review that case for risk containment classification. So what happens then is the incarcerated individual will receive a letter from the department called the Risk Containment Disclosure and Consent for Forensic Evaluation form. This form kind of explains risk containment, what it is, a little bit about the process, and it also tells them that they have the right to provide mitigating information to the committee to be considered. It tells them how to provide that information. And then the end of the form is a question about a forensic evaluation. And it says, if the department requires a forensic evaluation, will you consent to it, yes or no? If they select yes, the process moves forward. If they select no, the process stops and we apply a provisional risk containment classification because they're not willing to participate in the process. So then after we get that form back and assuming that they have said, yes, I will do a forensic evaluation and the process continues, Right now, that case is being assigned out to members from the field, members that the Central Case Staffing Committee have personally identified who have demonstrated to us an ability to do these kind of detailed deep dives that we're looking for, this ability to extract information and a willingness to, spend a few hours working on a case, compiling this information. There's 5 folks, I think it's 3 from the field and 2 from Central, that are on that review team and doing those reviews for us. So they do their review. It comes back to the Risk Containment Committee, the Central Case Staffing Committee. We look at the review and we make a few determinations. So the first determination we're gonna make is, do we want a forensic evaluation here? In a lot of these cases, we have 20, 30 years of history with these folks. They've been with us for that long. We have documentation of all the services that we've tried. We have documentation of their facility behavior, and there's just no questions remaining that a forensic evaluation is going to help us answer. I apologize, I lost my train of thought. So that's the first determination we make, is do we want a forensic evaluation or do we need a forensic evaluation or not? Also, we might have forensic evaluations on file already that we've already given. So
Would they have to do another one?
they might.
Okay.
They might. If we still have questions or we're still wondering, like, is there a way that we can deliver services differently to help this person be more successful? We might ask for a forensic evaluation to help us in making that determination. Or sometimes we have evidence that the individual has an intellectual disability or some other sort of neurodivergency that we want to know more about. How does this affect their criminal behavior and their criminal thinking? So in those cases, we might request a forensic eval to try to help us answer those questions and get that information. If we do request a forensic eval, again, the process stops. We submit the referral, the eval happens, we get the report back, and then we keep going. If we don't request a forensic evaluation, the next thing we're going to determine there is, are we going to apply a risk containment classification? Does this meet those core criteria to support presentation of an unmitigatable risk of harm to the community? If we do apply it, they get a letter from me saying, we've applied this classification. Here's why. Here's some resources you can access in the facility to help you process this information. And also, here's how you can petition for removal. Petition for removal can happen once a year from the date of their classification being applied. So if I apply a classification today, they can challenge it February 23rd, 2027. And they challenge it or petition for removal by sending me a letter saying, Director Pasha, here's everything I've done in the last year to address the factors that contributed to my risk containment classification. I would like to be considered for removal. I'll review that letter. If I determine that there's substantive evidence there that they have done that work and they have taken effort to reduce their risk, I'll move it forward to the Central Case Staffing Committee for further review and consideration of removal. If I find that the evidence is not there, then I will send them a letter saying, thank you very much. I don't find this evidence to meet the criteria for release consideration removal. You can next petition on the state. So a risk containment classification is a little bit different than an RSN designation in that somebody who's risk contained, we would not consider for provisional release or provisional release planning. They would have to have that classification removed before we would consider their release, at least under department controlled release mechanisms. A risk containment classification does not stop somebody from being paroled, as I'm sure you all know, and does not stop somebody from being considered for like some sort of probated sentence. But the department will not release an individual risk contained under our release mechanisms.
Does the forensic evaluation report, does that get included in the case staffing report?
I don't believe so. No, I haven't seen that. It'll be in OMS under attachments, but it wouldn't be incorporated with the case staffing itself.
I'm just thinking if we have a chance to review that, it might be helpful to know what the criteria was and what happened that caused this person to be put in risk containment.
Yeah.
A lot of times we'll get a hearing where we know that risk containment has been applied for, so we don't know what the status is yet.
Right.
But it kind of puts up a red flag that where is this at in the process?
Yeah.
We make a decision.
Yeah. Understandable.
Question. So somebody is, you know the cases better than I do probably. that are been there for a long period of time. We know their history. And the reason they are not being released, recommended for parole, because there's no program available. Are they automatically risk containment at that point?
No, not automatically.
So what is the plan for these? And I just had one not that long ago. He 20 to life, a long time. And the reason, and he asked me specifically, what do I have to do? I says, no program, we'll only do any program. And for corrections, there's no program that will fit his needs. So is there a plan in place for these? And they're not risk containment, so what are they?
Yeah, I mean, I can't speak for the risk intervention services on if there's any plans to incorporate or develop any new interventions. That's not my area of expertise. You know, that's a tough one because
I know it's a tough one, but it's something though that we see. So guys, again, no problem. Facility doing everything he's supposed to be doing.
Sure.
But the reason he's not, because he'll be there forever, basically. A guy kind of said that to me. He goes, "Well, I'm going to die here because there's no program available to suit his needs."
Right. Yeah, I mean that's a tough question. I mean there are certainly some folks in our system who we have either tried every intervention that we have and it hasn't been effective, or there's no intervention that we know of that is going to mitigate that person's risk. And that's, you know, where the department kind of has to balance its mission to protect the public and keep the public and victims safe, and also our goal to get folks successfully back into the community and reintegrated successfully. And if there's no effective mechanism that we have to lower that risk or mitigate that risk, deciding what the next steps are going to be is a challenge.
He wouldn't be risk containment though. He could be, but
He could be.
Not necessarily. I got it.
Yeah, he certainly could be. There are a few offenses that qualify for an automatic review of risk containment. So if this gentleman had a murder conviction, that would be an automatic review of risk containment. Or if designated as a habitual offender, it would be an automatic review.
Okay.
Interesting. Other questions?
I actually have a question about the forensic eval because we're seeing a lot of risk containment designations without a forensic eval.
Mhm.
And so I'm just wondering, like you said, that if the person won't agree, then they're automatically risk contained, but it seems like the department isn't using the evals, like they're not evaluating people really hardly at all. And so I'm just wondering, like, why is that an automatic risk containment if there might not even be an evaluation necessary in the case to review it?
Can you?
Well, so I see a lot of risk containment designations and no eval. Like
Sure.
our clients aren't really being evaluated. The forensic eval, I feel like when you guys first promulgated the directive, that there was more like referrals for evaluations, and
Yeah.
now, just given the volume, it'd be almost impossible to refer people for evaluation. So you said if they don't agree to the evaluation, they're like provisionally risk contained.
Mhm.
But like, I'm wondering, like, why wouldn't you review to see if an evaluation is needed? You know what I'm saying? Because like a non-confidential forensic evaluation can be really scary for people. It can be scary for me, quite
Yeah.
frankly. Like, and I'm pretty pro-social, but I don't know what they'd find out. But so I'm just saying, like, it seems like you're putting the cart before the horse if you're saying you have to go to an eval if the department doesn't even need one, but then you're going to be provisionally risk contained if you don't agree, but you might not have wanted one anyway. You know what I'm saying?
Yeah, that's
So-
a good question, Don. And I think I skipped over some information that will probably be helpful in providing some context here. So if an individual refuses a risk forensic eval,
Mhm.
and we provide or classify them as provisionally risk contained based on that refusal, it's not like we're just gonna never revisit that case and just let them be provisionally risk contained. We will come back to that case and we will conduct that kind of in-depth review and determine, okay, is this even a case that we want a forensic evaluation on?
Mhm.
And if it is, then now we're kind of stalled, right?
I get that piece,
And
right?
if it's not, then the normal process happens. Like you're either going to get a letter that says, okay, we've completed the review. We're going to request a forensic evaluation. You are now officially risk contained. Or we've completed the review. We've determined you don't meet the criteria for risk containment and the process is over.
Okay, and is there a gap between the provisional risk containment and when you would,
Right now there is. Yeah, for sure.
just because of volume, or like, is it a year like some of the other reviews? Or
Volume. Yeah.
Like, yeah.
Volume.
Are you saying there are people who've refused to sign that form and haven't been risk contained? Because I am not aware of any.
Are there people
who said
refused to
no,
sign the form
refused
and
to,
not been risk contained?
correct.
No, not yet.
Okay.
Not yet. I think we've only had like 3 or 4 refusals to do forensic evaluations. 2 of those were guys who said, I don't care. I want to complete my max anyway. So do whatever you want. And then another individual was a gentleman who originally had refused and then said, okay, I'll consent. And we just completed his review last week. So.
I have a provocative question. So I've been in prisoners' rights on and off for 27 years. And like level C was very limited. Like level C was a policy where like very few of my clients qualified for level C. And if they did, it was really incredibly like terrible for them. Risk containment is like, so many people are being risk contained. Like, where are you guys going to put everyone? Like, that's my question. Like, really, like, I don't understand as we move forward, like, where are people going to go? Are you just going to send more people out of state? Because if you're holding everyone, like, it seems so broad. Like, it seems like level C was discerning, even though if it was a difficult process for a client, but risk containment feels, I've seen, like, it's very, very, it's encompassing so many people. Like, what is the plan for?
It's everybody until everyone's been reviewed through the whole process. That's the thing. When it got revamped and triggered a year ago, everybody has to be looked at.
But so many people are being designated, though, is what I'm saying. Like where, if you're holding people, like, you're just going to send more people out of state, or like, what's the plan for increasing the prison beds?
That would be a question for Commissioner Murad.
Well, tell him I asked.
He knows you asked.
Dovetailing on
It's a fair
that,
question, right?
Yeah.
I mean,
There's litigation pending on this, so
dovetailing on that, what do we tell people who are risk contained and just got sent to Mississippi and so they lost their ability to do all the CCV? Because you went through all those things people can do going to community college and like, what do we tell those people who just got sent to Mississippi, who just got taken out of community college and all those things to be ready for their risk containment review in the summer?
I would tell them to draft a plan of what they want to do and why they need to be in state to do that and submit that plan to the out-of-state casework for consideration.
Can that be submitted at any time or do they have to wait? Like, can we help
submit
them?
whatever they want to their caseworker whenever they want?
Okay, so we should send that, if we do that with them, we should send that to Lori and she'll send it to you and the caseworker.
I don't need to be involved.
Okay.
The caseworker can handle it directly. Yeah.
Okay, because that question is coming up, hey, I was doing the things I thought I was supposed to do. What should I do now?
It's important probably to be clear with them that this doesn't mean you are going to come back to the state of Vermont, but knowing that they have a plan when they get back here, I think will be helpful.
Is there any chance that like, if they could, at the time they're designated, say, hey, I just got designated. These are the things I'm going to do. Can you please not send me to Mississippi?
They can submit whatever they want
Okay.
for
you guys do
consideration.
that to us all the time.
But they still end up in Mississippi.
But I think some didn't recently, didn't they, in all fairness?
Not the ones that I asked about for risk containment.
Oh, well, okay, we're talking about, all right, we can look at baby then.
Other questions?
And I did provide, in your packets,
Yeah.
board, and in the folder for everyone, the copy of the directives for you all
Thank
to
you
be
for
able
that.
to
Thank you.
review.
Yeah, got
That's very helpful.
I provided them to once
Yeah.
before, but I provided them again just to have it out there.
Thank you, Jordan.
Yeah, of course.
Thank you.
Thanks for having me. Nice to meet you all.
And I don't know if you want to stay for our next topic around the out-of-state pending charges and non-extraditable warrants, because it kind of fits in your shop if you have just a couple minutes. It's not a big, huge topic. Just figured, well, I had you and I had prisoners' rights, so I might as well. And I know it came up last week.
Yeah, go ahead.
All right. So as we're seeing, I think we're all seeing in the population, there are more individuals or we're seeing an increase that are coming before the board that have either a pending charge out of state or a non-extraditable warrant out of state. And I believe that they're coming, there's questions, and I know, Tom, you had one last week around, oftentimes there's not release planning because I believe it's been a change to not recommend individuals with a detainer or a warrant to be paroled. So we had a conversation with Emily back a little while ago because oftentimes Dean especially was referring folks to prisoners' rights to assist them with that non-extraditable warrant to try to get it solved. And so as we found out, and as caseworkers have been saying, and everybody's been saying, is that most likely they need to appear in person to handle those warrants. So if we have one, if they contact prisoners' rights, then we'll get an email back with any work that has been done. So I just wanted to let folks know that there's not a lot of recourse around many of these because the other states will not see them by phone.
Well, it's kind of like being in debtor's prison. We had a case, it's like this poor guy, he's at his minute, has a plan in place. Massachusetts says, if you show up, we will dismiss your charges or whatever, but we're not going to let you do it by video. We're not going to do it in person, anything else. So you're kind of, and they won't put a detainer on him. So here's a guy that's taking your bed spaces that basically is eligible to go, but he can't get out because he has charges, non-extraditable charges in Massachusetts. I mean, I my heart goes out to these guys because he's done everything he's supposed to be doing. And all he has is that, and
All he has is pending charges in another state.
Yeah, and but they've also said that this one case in particular, if you show up, we'll dismiss your charges because you've been in jail for the last 2 or 3 years. You've fulfilled your requirement, but we're not gonna extradite you. You can't do it by phone, and you have to be in person so we can dismiss the charges. Meanwhile, the charges are out there till he maxes out.
Yeah, well, I mean, we can't force others.
I understand.
To do that.
There are a lot of cases too where we'll parole somebody with a pending charge in another state. We've taken a look at what that is. And we give them a period of time, like 30 days, 60 days, whatever, to take care of that as one of their special conditions. And obviously, if they're risk contained or RSN designation, that paints a different picture of whether or not they're going to be able to do that.
And I think what I was just bringing up is that the conversation that was had, that there's not a lot of, for a while, I think we thought that the board was thinking that there was more information that could be had if we sent somebody to prisoners' rights to do the digging. And really, there's not much.
Well, and a lot of that comes from, we asked the individual, do you have somebody working on this case for you in another state? And they don't know.
And I think the problem is that, and correct me if I'm wrong, anyone that's working on these, that nobody can work on it because they're not there. They need to go and work on it.
Well, so like in New Hampshire, the public defender's office won't open a case. If they're in warrant status, it'll be closed. They won't open it because there's a risk. It creates conflict issues for them if they're constantly working on cases that aren't open. So there's like 2 counties in New Hampshire that if I reach out to them and it's a misdemeanor, I can probably get them to set up a telephonic plea. And because I'm licensed there, I don't feel too bad helping the person sort that. Like I actually know what I'm doing there. But if it's not like 2 counties in New Hampshire, my advice to that, I said, I'm just going to write to MJ and say, hey, this person reached out to us because you guys said it, but there's nothing we can do, really.
Yeah, and I think that's fair, right? Like, if you want to refer people to us, and we can try to solve the problem,
Yeah.
but then we might be coming back to you to say, like, this is all the information we have. We can't go any further, but you could do what
Well, in
Dee
some
mentioned.
cases, you are able to find out that there is an attorney working on their case in that state.
Yes.
And we get the information that needs to
Yes,
be addressed.
right.
Yeah.
We'll take it as far as we can,
Yeah.
but then if we can't solve it, short of,
I just want to make sure that the board is aware that
Yeah.
most of these cases cannot be solved without the individual actually being.
But it's also my understanding, and it never used to be this way, if an attorney in another state or whatever would be willing to put the person on the phone, that corrections is not willing to go along with it.
That's true. The policy doesn't let them be put on the phone. And so on a couple of them, because I was involved, I called them on the attorney line and put them on the phone with like the Lebanon District Court. But that's like because I was able to do that in that unique situation. But yeah, that's true that we can't. Yeah, it's hard. A lot of times. And again, most of these, there's 2 kinds of cases you're going to get, right? You're either going to get the reason they're not extraditable is because these are fairly minor charges. So like that tells us
that's what's frustrating.
the other case you're going to get is that the warrant is not for an untried. It's not pretrial. So it's a parole or a probation or a drug court or something felony violation out of state. And in those situations, I think the best answer at some point is parole to detainer. But in the misdemeanor ones, the best answer is at least to sometimes give them a try to go, you have 60 days to deal with Massachusetts or whatever, if they're otherwise ready for parole. So, yeah.
In the past, again, going back to my history.
Yeah.
If I could see a guy get out and save a bed, I would put the person on the phone with, and I know that's changed dramatically. But I think that would be something that it's the corrections advantage to have somebody, a simple phone call, have it get out would be, help us out too.
But they can do what Attorney Wines just described. They can use the attorney line and have that call if the receiving court do that. But if we had to put everyone on camera
I
for
know.
every single hearing that these individuals had all over the countryside, no one would ever have any hearings at all.
And yeah, and that's the same with us. Like, we can't call everybody into court. But again, I'm sympathetic to the people who have, like, in New Hampshire, for example, a misdemeanor B that they're not qualifying for counsel anyway, because it's only payable by a fine. That's the maximum. So they're not going to get an attorney no matter what. So then those are the people that, again, if they are in the right, there's a couple counties that are pretty good about this, but other than that,
And it's not, as I look at these cases, not a lot of them.
No.
And the vast majority, which is interesting, is the caseworker in the case has tried to help them get in touch with whoever.
right.
And they have the solution to it in hand and let us know and go forward. It's the ones where we don't know and nobody seems to know where to go from there.
Well, I had one recently that was sent to us too, that sometimes people will have a warrant from a police department, but it's not. So you call the courts and they're like, we don't have a warrant for that person. And so those are the ones that are really the hardest to deal with, actually, or the ones that aren't in the system yet. And that's when I said to MJ, we're just going to say, hey, these are the steps we've taken. There's nothing more we can do. Yeah.
Good. Other questions? Hey. I think we're all set. Thank you both for coming. We
Yeah, thank
appreciate
you.
your time today.
It's nice to meet everybody.
You too.
Sure, our paths will cross again.
Yes.
You have to go see all our favorite caseworkers. Are you going to see Jeff? Is he the one who set him up?
No, not today.
Is there anything else that you guys have that you wanted to?
No, but I'm sure we'll talk and then send MJ if there are things that came up today, because there's always more questions than answers.
The violation is going to be an ongoing challenge.
That one's gonna be an ongoing challenge, and we probably
It's a big
have
one.
50 cases in our office, court cases about risk containment at the moment, if I had to guess.
You have more?
Maybe more. We may have more, but that was just like my rough, like, that are actually in litigation. So,
Interesting. It's
All right, I have to go to the St. J jail. So I have to be there by noon. I've noon to 2:30 with my
it's
clients.
chicken
So.
patty day.
Huh?
It's chicken patty day.
Oh, darn it.
You all are structured decision-making framework coding
Oh.
conflicts.
Ooh,
That
looks
sounds
really
exciting.
interesting.
Yes, I like that.
We love it.
Wait, what is it? Is that it's the release interview decision, the
So
SDMS?
we do a structured decision-making
Yeah.
framework for each case. And then every month we have a bunch of cases where,
Oh,
say, one of the board members of the three disagrees with one of the codes. So we bring that up and say, okay, why did you select this code? Like agriculture.
That sounds exciting.
Don't you mean one of the board members is correct and the other two aren't?
But no, it's good because
It brings
we're
us
trying to
into
get on the
being
same page.
consistent.
Yeah, I'm trying to standardize it.
Yeah.
Yes.
I get it.
Nice seeing you in
Well, it's
person.
nice
so-
seeing you.
Really nice seeing you
See
all.
you on the big screen.
I'll see some of you tomorrow for overflow day. There you go.
Yes.
Take care.
Thank you. Nice to meet you.
Nice to see you again. Good luck with the bill. I'm so happy to hear about it. Yeah.
Didn't you?
I was ready.
Did you
Yeah. Oh,
catch
yeah.
that?
Yeah.
It wasn't so much with Dawn. Anyway.
I gotta look here, see if my name's on any of these.
So there was tension between.
Listen, if you go neutral, you'll never.
What'd you say, Wayne?
Funny you should say that. A couple
Dino,
times.
didn't you mean to say that,
You can say neutral.
didn't you mean to say that one of the members was correct and the other two were misguided?
I didn't mean to say that.
Yeah, that's what I thought.
It's always clarification that needs to be done. you
Yeah.
know?
There's a certain person here who he goes, well, they really had to go really above and beyond not to get the neutral in these cases. I said, so yeah, Oh, okay.
So-
You have to be the golden person
Yeah,
to
see?
get a mitigating.
Oh, okay. I thought you said to get a neutral.
No, well, mitigate, no,
Oh.
neutral, she,
No,
neutral.
no.
Scared me, I thought.
I know, no, she.
Mitigating.
Yeah.
You have to be like,
Right, look, I laugh, sometimes I'll be doing things, I say, okay, that's all.
one of the things, just so everybody knows, we do have an executive session in part where we're gonna talk a little bit more about the legal advice on parole violations.
Want to do that next, or?
Well, we've got our roundtable and our
Okay.
SDMF stuff, so I'm not sure where MJ wants to go next. When she returns,
So they're talking.
but if everybody wants to take a quick break.
Yeah.
Wait, for the-
Everybody back? Where's Wayne?
Wayne's out shoveling snow,
He's out shoveling?
he's out shoveling.
Katie, you're
Yeah, just
muted.
come in from the blizzard.
Oh, good.
Sorry, yeah, I had it's still coming down out there.
Yeah,
Keep it down south, keep it.
it's all yours.
Well, you're
like
down
driving
south
in
a little
snow.
too.
Yeah, when I was leaving, it was snowing in Rutland, but I wasn't,
Well, hopefully you don't have to drive back into it. It's not too bad.
No. Just the mountain is all the part that was bad, so hopefully.
Okay,
Yeah.
so we have our SDMF review. Do we want to take on that next?
Or do we even do roundtable next?
Or roundtable?
We skipped. Real quick, I emailed Tim Connors, come on about 11:30.
Okay,
So we can jump to exec session then. So any violation, any specific legal questions that you might have around violations, I would suggest not doing it in roundtable. If that's your roundtable, we'll take that. Any
So-
legal stuff we'll take in executive session.
okay. So just so Angela and Katie and Wayne know, in our deliberative session, or excuse me, our executive session, we're going to be talking about the violation issues. And Tim Connor, our attorney, who MJ and I met with last week sometime,
Yeah.
and posed some questions to him. And I'm not sure what he's going to have for answers, but it's a discussion about how we're going to proceed without witnesses when confrontation is requested, essentially. And we'll
Good,
work on that.
that would be helpful.
Yes.
Good.
Mhm.
So getting back to the roundtable.
You know, I'm not a board member, but I do have something because some of you may have seen the email invite. Wednesday morning at 9:30, there is going to be an Association of Paroling Authorities International Northeast Regional Meeting. I'm a little slow to be putting this on.
What time?
9:30 to 10:30.
10:30?
Anybody who wants to join, feel free. I sent it all to you. It's basically all the Northeast states coming together to talk about what's happening in your jurisdiction and just to get to know one another. I'm going to try to start, I'm supposed to be doing these quarterly. It's been a little off. So I'm going to try to start doing these more. We wanted to get one in before May. So if you can join, feel free.
Okay.
Don't feel like you have to if you don't want to, but
I'll try
I'd
it.
like to, and I'm not flying out till a few hours later.
yeah,
so.
so
I gotta work, but not until.
I saw an email from you, I saw the links on the email. Okay,
it's a Teams
Great.
meeting. So I just figured I
Thank
would
you.
send that, I would let you all know.
okay,
Great, thanks.
thank you.
Sam?
I mean, I just have listened to all the legislative stuff every time MJ has testified, so just thank you for fighting the fight for us. That's all I got for right now.
I watched too, MJ's done a nice job and I think she's almost should be on that committee.
She is.
Yeah, she's right in there, Phil.
A few of them have asked me to, if I wanted to see.
So her Barry representative is probably nervous that she,
I could go
She
some.
is on that committee.
Yeah.
God help us. No, nothing. Things are going smoothly.
that's good.
Mine are sort of like legal questions, so I will wait until we
Okay,
get into executive session.
okay. Katie?
My main thing too is because it just came up. I wasn't, when we first started talking about the whole changes, I didn't quite grasp how it was going to affect us. So, but then all of a sudden it started coming up in hearings. So I'm really eager to hear more about how we're going to navigate that. when we talk about it in executive session.
Angela?
No, I don't have anything. I do need to zip out at 12:30 though to intercept a delivery, so I apologize for that,
Okay.
but that's it.
Okay. Wayne?
I got nothing.
I got nothing. Don't-
I got nothing.
Oh, God, help us.
Other than MJ is doing a stellar job in the legislature. Just gotta push that money thing a little more, MJ.
Yeah.
And, well, you missed part
Especially
of
the
it.
50.
Yeah.
Get him
I'm
to bump
navigating
to
some
50.
I'm navigating some politics right now.
Yep. And there was a lot of that going on.
Maybe MJ, they'll pay for lunch for you. I mean, that'll be, it'll be like, they have a lunch.
If any of you haven't seen any of the hearings, you can watch them online through YouTube by looking up the House of Corrections or the,
I can send out the link.
yeah. it's,
Oh, that would
Send
be
it to
great.
everybody.
and
Yeah,
then
send
you-
that,
You
Sam,
pick the
that would be
session
great.
and the time, and then you can listen and watch to the hearing and the questions, and I think it's very informative.
Yes, it is.
And I did drag Tom up with me once last month, and we testified along with MJ. And as MJ has said, the committee is very supportive of the board and understands our issues. Our hope is that they can spread that out to the rest of the body when it comes time. It's pretty clear that that group has a pretty good understanding of what our concerns are, our needs are, and are working to try to help us. They're not the money committee, but that could follow with it,
They have some
depending on,
influence.
they do, yeah. Yeah. So,
And then, like I said earlier, the next draft will be the committee will be hearing that, will be going through the next draft, which has not been released yet, tomorrow at 3.
I can send the link out this afternoon.
so other than that, the only thing I've got to add to it is, there are other issues in the legislature that come up from time to time, but so far this has been the main thrust of everything. And MJ and I had a brief meeting with Emily to talk about the violation issues a few weeks ago. And then last week, as I mentioned, we met with Tim Connor, our legal counsel, and posed some of the same questions to him. So, which we'll discuss when we get into executive session. The other thing is I have not heard anything from the governor's office yet on the new chair. I know they're supposedly working on it, as I've been told. So no news at this point. If there's nothing else, then I would entertain a motion to go into executive session to discuss legal issues.
I'll make a motion to
Second.
go into executive session.
Thank you. Motion's been made and seconded. Is there any discussion? All those in favor signify by saying aye.
Aye.
Hi.
Any opposed? Okay, we're unanimous.
Okay, bear with me
Yeah.
while I open up executive session.
Okay, so SDMF forms.
Yes. Hold on just a
Everybody has a
second.
copy, and MJ, I take it you're gonna bring up the cases. or-
I am gonna bring up the cases.
Awesome.
I reviewed them this morning and I was chuckling to myself.
What were you reviewing them as I was putting them in?
Yeah, yeah, I saw, I said, oh, she has them there.
I was a tad bit behind.
No, I saw this morning.
I'm a tad bit busy, sorry.
So I
You
scrolled-
are? I
I
never would have
can't
guessed.
Hey, I was working last night, I was working this morning before I came in.
No,
I asked my husband to take my son to camp so I could get here a little earlier.
can't.
Files for.
Yeah, he
SDMF.
said,
Cool.
there's no
It's-
school this week.
February break.
Oh, God, that's right. You northern people have it this week. That's right.
Yes,
What a stupid thing, you know.
it's The Opera House this
You know, why
week.
don't they have them all the
They
same?
did it at one time because of ski areas or something ridiculous and
Yeah.
they never brought one back. That's just.
All right, so this is a little bit different than last month. So I did add December on because I felt like I needed some variety to talk about.
Okay.
I will say, January and February
We're phenomenal.
were phenomenal. for all of you.
Well, everybody was thinking about Christmas in
Right.
December.
How?
I
That's
will
right.
say, you guys took a because October, November,
I didn't see.
October and November when we looked at them last month, they were not so great. And December was okay too. So the cases I was looking at talking about today,
Uh-oh.
so for those of you that are on the screen, I have put the offender files in, and you can go into their last hearing. So it would have been either 2025-12 or 2026-1, probably, maybe 2.
I see you have.
And you can go into that folder. We're going to talk about Daniel Guyette first. And in there, looks like we've got Dean, Angela, and Katie. So in there'll be a file called SDMF forms.
Yeah.
And Dean, I have yours printed off.
Oh, okay. Thanks.
Sorry, Katie and Angela, you'll have to go in and find it, or I can put it up on the screen. And
I see where the files but is the SDMF form that we
Hold
did
on.
isn't in there?
Yeah,
Hold
I
on.
can't find the SDMF.
Hold on, I will show you. Give me a second. Give me 1 second.
Oh, shit.
Let me share my screen. So I'm in can you see my screen?
Yes.
So I'm in the files for SDMF review. So if we go to Daniel Guyette,
Right.
then you're going to want to open the 12/20/25 IPRR.
Okay.
And in there's a file
Gotcha.
called SDMF forms.
Got it.
Yep.
And so when you open that, it'll be all of your forms combined. So you'll just have to go to your pages.
Okay.
Tyler Bushy.
So we're going to talk about Daniel Guyette right now.
Daniel Guyette.
And, but okay.
So hold on just a second.
It's Katie, Angela, and me.
I got it. I got it now.
So with that one,
Bad list.
it looked like it was release plan. We have Dean and Katie with an aggravating and Angela with a mitigating. So I was hoping to understand a little bit more.
I had no release planning done that was approved.
Oh, I put down has realistic plans. However, his plan was not approved by DOC.
And Katie looks
Yeah.
like
And I
Yeah, no.
had no release planning currently on Pathways waitlist.
Yeah.
I always, if there's no release planning done, I'm usually always aggravating.
Me too.
Me too.
And so Angela, there was some done, it just wasn't approved from your perspective.
Right, from my perspective. So I guess just because, yeah. But I
Wonder
can
if
see where
that
that
would be
would be
better.
aggravating.
yeah, I'm trying to pull up the SDMF thing. I didn't get my notes ahead of.
Mine's in Florida.
I will get it in just a second. I just didn't get that far ahead of myself.
But it's not really, it'd still be aggravating, you know?
And Daniel was denied.
Yeah, by all three of us had deny.
I wrote on the back that he needs to develop an approved release plan and set up a community-based sex offender treatment program in a structured plan. So he's a sex offender as well.
Yes.
Mhm.
I would
Yeah.
think that would-
I think he went from high risk to not high, or one or the other.
Well, his Vaser was high and his ORAS was moderate.
Right down.
So Angela, on your mitigating for the release plan, it looks like one of the criteria is that he has set up his community aftercare programming, which in his case was sex offender treatment programming, which needed to be set up.
Yeah, I don't know. I guess I just missed it. I thought, I don't know. I'm trying to like remember the case.
Yeah, I know it's hard.
I think I'm looking at the coding right now. Mitigating, so aggravating is the offender lacks a concrete, specific, realistic release plan. Mitigating is the offender has a concrete and realistic release plan addressing most of the community stability factors, stable housing, prospective employment, pro-social supports, and realistic plans to mitigate risk factors. Neutral, the offender has concrete, realistic release plans addressing some of the community stability factors with several factors not adequately addressed.
Okay.
Offender has plans to live with a supported pro-social family member, but it's in the same crime-ridden neighborhood where his criminally involved peers live. The offender offers general statements about risk factors. I need to avoid people, places, and things I associate with my drug use, but cannot offer specific details or strategies to manage those risks.
Yeah.
I think from me anyway, looking at Angela's thoughts, I would have thought neutral would apply there.
Mm-hmm. That's what I'm thinking.
What do you think, Angela?
No, I agree. Yeah. I get a little confused sometimes when I'm doing it because it's just like, well, this kind of lines up, but that doesn't line up. And
Yeah. That's okay. That's one of the reasons we like to go over them again is it helps us work on being consistent.
right.
Okay.
As we're talking about, before we go on to another case, I think I'm actually seeing a previous conversation kind of lend to this release planning domain around, because one thing that came up in everybody's comments was it's not approved for release by DOC. So how do we, and I think we've had these conversations of how do we juggle that decision making around, do we parole somebody who has not been recommended by DOC or they're not releasing and so forth. And so part of me, I'm just thinking in my mind, if I was a board member, I would want this release plan to be mitigating. And I don't know how all of you feel. This would be one code that I would want this guy to hit every mark, or this person to hit every mark on. So I just didn't know if kind of tying that conversation into this.
Carry a lot of weight.
Yeah.
I think it does.
Yeah.
Yeah.
I didn't know how others feel, because that would be something that I would almost expect to see is a lot of M's if on this domain, if you're gonna grant potentially. So I just, I didn't know, I thought it was a good this was a good conversation starter.
It's hard to give mitigating on a lot of cases,
Of
but
course.
if there is a decent plan in place and it can be, you can signify that it's neutral and you think where they're going has a good probability of success, that's fine too, because you're not going to have mitigating, at least in my view, unless you know for sure it's going to.
Yeah, the trouble with the plan is you don't know if he's living with his victim. You don't know if it's a drug house. You don't know. It's been. I mean, that's the problem.
I don't disagree with MJ, but one of my famous slogans is they're warehousing them. A lot of those venues, you're never going to get them mitigating because they're not participating. When I say they're not, it's DOC that's not participating and doing anything to help this guy mitigate.
But what is it? But also, what is he presenting? So I would expect that.
No, I agree with you, MJ.
I'm just saying I wouldn't expect to see an aggravating in this column. If I saw an aggravating and you granted, I'd be like, whoa, let's back up the horse. Let's talk about it.
But I have an aggravating release plan.
But your question is right. Why aren't we asking those questions? I'm just thinking myself, and I haven't, but I should. Okay,
yeah.
But good point.
Something that I ask sometimes is when they do have a release plan is like, who are you living with and where are you living?
Yeah.
But there's a case, so you also could ask you'd also ask the PO, would this place be approved if it wasn't?
Right.
Or you should say,
Yeah.
or you could you could say to the PO, maybe not, ask them if it
Yeah.
would be approved.
Right.
Are you aware of any history with this,
Yeah.
this residence?
Yeah,
And not, and then that kind of takes it off the spot, because when you ask, would it be approved, you're kind of putting the PO in a hard spot where if you look, I know.
what I have
I'm
asked,
trying to balance the partnership.
what I've asked Pio in the past, so has this residence been approved previously?
Right, yes.
That's what I've asked, and
That's a good point.
Yeah.
Or are you familiar with this residence or this area? Because they may have other people in that neighborhood.
because when we were discussing, that's the question I asked, was,
Yeah.
has that been, they said, yes, it has been approved previously.
Yeah.
So, all right,
Absolutely.
good point,
Okay.
MJ.
What's next?
All right. They're a little bit darker gray. Bruce Lefebvre, which is, let's say just a
Okay.
second.
Sadie and
Katie and Tom.
What? Then I was, out the hook, then I was on one, I thought, where am I?
Here you go.
Where
Where is it?
I
Where
was,
is that? Let's see.
community.
I was not.
What page? I can't see it, that's it.
Yeah, I don't know
It's
either.
in January.
It's in January.
January Burlington Completion Parole.
Yeah, Jamie, find it here.
And we are
Oh, yeah.
looking
He's
at
the one who asked me to do
institutional
this.
community behavior.
Oh,
And,
there we are.
Oh, so you
where,
guys
I
are
don't see it, where is it?
Keep going.
I'll keep going.
Right,
There.
right there.
Okay. Well, obviously, let's see,
The others are at fault.
obviously, yeah. Yes, okay, I agree. Okay, so I put down, yeah. Major and minor DR in the past 3 months.
Community behavior, is that what we're talking?
Yeah,
Yes.
Yes, and Katie, you had no DRs compliant while on furlough. And I think that's
Well,
why you gave
because-
them a mitigating.
Yeah, because when my understanding of that behavior is we have to look at their most current release status. So I was going by what they've done on furlough, their behavior while on furlough, which was their most current release
So
status.
when you saw them, he was on furlough.
Yes.
Okay, I would agree.
And
Wait,
he was doing, from what I remember, he was doing great on furlough. They,
Yeah.
you know, they
But
were
how long
saying
you
that
been
he
on-
was very
how long was
compliant,
he on
doing,
furlough?
But the criteria says the most recent behavior, is it they're on
But-
furlough or in the?
but he just,
But I thought we were 3 months.
yeah,
I thought we looked at the last 3 months.
I think he just barely got out.
Hold on.
I don't,
I'm trying to defend Katie here.
So,
So his
I do
last,
remember.
okay, so his last minor and major DR were in 2024, and the major was dismissed.
now,
Okay.
Okay,
So
maybe
let me- I'm gonna find out when he was
Oh,
released. Give me
maybe,
a second.
maybe I looked at his other history.
I always put in on.
We
community
revoked his
supervision.
parole in November of 2024. I can tell you
Okay.
that.
Yeah,
I'm working on it.
Maybe I looked at, maybe I saw the date and didn't realize it was, 24.
He was released onto furlough on January 28th, 2025. No, wait. Hold on. I gotta. Now. No,
Just
actually,
took time to look in the
I
notes
thought
of it.
yours was good, right?
Hmm?
Yours was good on that.
my neutral.
this one looks interesting. It looks like he was at the Vermont State Hospital from November of 2024 until
Sometimes
January of
in there.
2025. He was on furlough from January 28th, 2025 until he was paroled in January of 2026. So he was on furlough for a year.
Right.
So Tom, you got major DRs in the last 3 months.
That's right, did he look in the?
On his parole
In his,
summary,
like, look at the kind of DR history, can you look that up?
yeah, just a minute.
There's somewhere, either I looked at the wrong date or I was,
Because on his parole summary, it has a major DR dismissed on November 2nd, 2024, and then he had a minor DR on December 26th, 2024.
so I looked, what I did was I didn't see the 24.
Because he would have been on furlough during that
Right.
time.
Right.
No, what I looked at was the 24. That was my, okay, there's my mistake.
He's been out for a year.
So you dragged the other two.
I
into
dragged
that
the other
sordid
two.
affair.
Yes, I did. Yes. Oh, that's probably the one I had, was that, which were, I had like 25 of them to do or something, I don't know.
So, wait a second though, I want to follow Pat's thoughts on her neutral though. I'm
Yeah.
kind of curious as to her neutral.
I guess because he had a pending DLS. So it wasn't,
It's not institutional community behavior,
it's
That's
community behavior.
Would be
Yeah.
community.
but I thought that, okay.
He'd been in the community
And
for
in
more
charge,
than
yeah,
3
in
months.
charge.
And he had picked up a DLS. I couldn't give him mitigating and I couldn't give him the aggravating.
Oh, that's
So
fine.
neutral was the,
Where did
No.
you pick up the DLS? It must have came out in the
yeah, he had a pending
hearing
DLS.
because it's nowhere in his parole summary.
It must have come out during the hearing then because he had a pending DLS for a DUI.
Well,
He was on pension for a DUI.
Yes,
He
yeah.
wasn't drunk again.
Right. I picked it up someplace in there.
No, I know mine was.
I know I didn't make it
Mine,
up.
I didn't look at the date, that's where mine.
Well, that's good. The rationale for
Yeah.
making that neutral is
Yeah.
good. Yeah.
Well, I'm just curious, I'm curious. I want to dig a little bit because I'm
Yep.
curious where the deal, because it wasn't in the parole summary at all. And then the other two didn't mention it.
Yeah, I don't remember the pending.
Well, I didn't make it up.
You may have self-admitted it.
Wouldn't that have been in the parole, in the summary though?
Theoretically.
MJ's
Unless it
looking.
happened after the parole summary was written.
Just innocent.
Let's
He has
see.
no pending charges.
Well, I don't know where
He had
I,
a DLS for DUI back in 2024, and that might have been the reason why he was revoked.
I think it was still pending. On 10/9/24, Mr. LaFave was charged with a new crime and is pending a DLS. This makes Mr. LaFave ineligible for furlough. Oh, I may have picked it up there and,
Did the same thing I did the date.
yeah,
Yeah, because I was disposed of on December 8th, 2025, so
Oh.
that might have been, that one I could see, because it was only a month,
I know mine,
Right.
I know mine
that's
was.
probably it then.
I
Because
just,
but it was dismissed at the time of the hearing.
I gave him a neutral.
oh,
I
it
didn't think he
happen.
was aggravating and I
No,
didn't
that
think he
makes sense,
was.
a neutral makes sense.
Yeah.
I'm just saying it wasn't still active at the hearing is what I didn't say
Okay.
what didn't happen, Wayne. I heard you.
Okay.
I heard you.
Did you say I was wrong?
So
No.
no,
He's
MJ.
making fun of me.
before we leave that,
Good
in the
thing.
case staffing, it does say it's pending.
Because the case staffing is, did we look at the date of the case staffing though? That's another
No.
thing you need to look at too.
12/12/24.
Yeah, it's
Yeah.
just that, if you read through that and you're trying to gather information from the case staffing, it
Yeah.
does indicate in there that it's
So that's something you want to follow
Yeah.
up on.
it's a pending DLS.
Yeah, so make sure you're looking
The
at
date.
dates,
Yeah, that's,
Mhm.
especially if they're out on furlough.
Okay.
Make sure you've got the most recent case
No.
staffing.
I think I was getting a little punchy at that time probably or something.
But they printed it in January, but that doesn't mean anything.
Right.
Right,
Well,
Exactly.
and it might be when I printed it for you all too,
yeah,
because they're entered into OMS and then
Right.
when you
Yeah.
print them, it gives a different
Yeah.
date. All right, we ready to move on?
Yep.
Next one is Harley Porter, and this
Oh,
one just
God.
happened 2 weeks ago.
oh,
I remember this one.
And we got Wayne, Angela, and Pat.
I know. It's person.
which we're gonna be
Well,
seeing
when
this
it
person
changed.
next month.
All right, well, I will not be on that one.
Okay,
When was
so
it?
you need to conflict out of.
Yep,
It
I
was
will.
Okay,
February
you
12th.
know.
I will.
I'm at the point now when I go, I look at all of the cases for the next month because I never know when one of them's gonna show up as a conflict.
All right, so this one is offender change. I have Pat with an aggravating, Angela with a mitigating, and Wayne with a
Neutral.
neutral. And this is another domain I'd be curious to
Yeah,
granting parole with an aggravating as well.
I
Has nothing to do with you, Pat.
No.
It's with all of you, I
I
would
did.
question.
I did aggravating because, well, if it wasn't for the fact that she was 8 months pregnant and they were gonna send her to the Lund home, I didn't see that there was a big change in her. And that's why I put aggravating, but I did put that I was gonna grant parole because she was going to the Lund home. And she was gonna have a baby in a month. But I didn't see a big change. Can you what?
Can I ask a question?
Yeah.
So you didn't see a big change in her, so she's not meeting those change factors. But because she's going to the Lund home, does that mean she's not gonna be a public safety risk or a risk to other people at the Lund home?
What were her?
I know, I'm just
No.
talking out loud. I'm just concerned with an aggravating unoffending change granting. parole.
Hmm.
And then
She had
I go the
substance
opposite,
abuse and mental health issues.
and then I go the opposite to Angela to the mitigating. Wayne, you've fallen in neutral. I'm gonna stay away from you right now.
That's good. How can you fight with a neutral?
What was
We're number
Wayne's
one.
reasoning though for neutral?
I'd be Sweden in this matter.
I wanna know Angela's reasoning for mitigating first. I wanna go to the two extremes
Yep.
first.
So during our interview and questioning with her, she seemed to accept, her criminal past, and she was doing everything she could to try to prevent that from happening in the future. And she was using the Lund home. It was a high risk pregnancy, so not only to help her with that, but to establish employment and some mental health, help. Moving forward, so that way she could have more visitation with her other children and be successful as a parent and a member of the community when she was going out, and she was working with Mercy Connections and doing extra programming that was not required of her.
okay.
All right, wait,
Okay.
we're gonna address your neutral now.
What
Because based
question
on
do
what
you
you
have?
wrote, it would have gone aggravating.
Oh. What do you write?
Unidentified by the above criteria.
Uh-oh.
Programming, growth, motivation, identification, risk factors, triggers with strategies to manage. She didn't hit any of those bars, but Lund home, working with divas, doing really well. She had some letters of recommendation, I believe, maybe not.
Pretty mitigating that.
Gotcha.
I would have gone mitigating other than the fact that she didn't ring any of the bells and the
Mhm.
things I have to ring a bell on, so I like neutral.
Yeah, I could see that.
Right.
I can do.
I kind of like mitigating after all that.
So Pat's moved up to neutral.
Is that up or
I
down?
could not find mitigating.
Understandable.
Yeah.
Is that up or down?
This is the other, so once we get to offender change and release plan, these are our forward thinking
Yeah,
Right.
coding areas. And that's where I'm more of, if you're granting somebody should be ringing that at least the neutral,
Yeah.
if not the
Mhm.
mitigating, if you're gonna
Yeah,
grant.
well, you see, MJ, a lot of times I use that sentence a lot that I use there because I'm reading literally there, it's evidence of change through programming. And
Right.
Right.
then we say we're supposed to be looking forward.
Right.
So how do you do how can you have both?
Yeah, and I think it's
How
a
can you look
matter
at
of,
the future and have evidence?
and I
Can't do
think
it.
the neutral fits a little bit because they should be showing you some evidence of what they''t been working
Yes.
on, and then they
Right,
seal the deal
right.
when they're
Yes,
released.
that's what I look at, is what they've been doing. If they're in program, but still picking up DRs, chances are they haven't changed much.
Mm-hmm.
Yeah, and I think these are probably the release plan and offender change are probably two of the hardest domains right now that you're facing.
Mhm.
Because not many people are coming through with DOC recommended release plans, so
Right.
you're having to.
We got to
Offender
kick it out
change
of.
is the biggest one
Right.
for me.
So those are the only three that I picked to talk about today. But it felt like these,
Thank you for doing that.
yeah, I think the ones that we hit on today are the three that I noticed were coming up more and more.
Yeah.
Yeah,
Was offender change, release plan, and institutional community behavior. And I will say, just a reminder, I appreciate you all filling out comments and board member votes, your reasonings at the bottom, because while we've been sitting at the meeting, I have just been asked for a reasoning to why you all paroled someone. So I have to go through and look at that, and I'm gonna have to review the whole case to not justify, but to give the information
Mhm.
of why you paroled someone against DOC's recommendation.
you get those every time.
I get those once in a while. I will say, I don't get them every time I do courtesy notifications. This one's actually coming from the AHS Secretary's office, which I don't get very often.
Ooh.
I will say I met Commissioner Murad, 2 weeks ago and had a very good conversation with him. He may want to review some of these cases of where you may have, overrode, I wouldn't say overrode, you granted when they are not recommending release, just to see what you're looking at, what's happening at the hearings. He's very involved.
Good.
And he made a very good impression with me, and we had a very candid
Well, that's great.
hallway conversation at the State House the other day.
Oh,
It
that's good.
wasn't planned, it just we just happened to be going to the same room.
Oh.
Cause he didn't
Happen to invite him to come and meet us?
eventually.
That'd
He's
be
still
nice.
getting his feet too. He's been very supportive of the H559 bill as well. He's been in the room for a couple of the testimonies. Lori Fisher has been there for DOC and in support of us. She testified as back in her role when she was our attorney to some of the attorney issues and so forth. DOC has been right there with us the whole time, in support. So
Yeah, it would be nice to meet him when he gets his.
we'll get there.
Great.
He's still busy trudging along, figuring things out and
Yeah.
meeting. And he seems to be a very busy guy. But I will say, just the 5-10 minutes, it was just nice to have some candid conversations.
Anything else? Anyone have anything else for us this morning?
It's afternoon now.
No.
Yes.
That's it.
Oh, thanks, MJ, for doing all the agenda and stuff.
All right.
Yes.
Yeah,
Great.
definitely.
Thank you.
And
Thank you.
like I said, if anyone has if you've seen things that come up in hearings that involve substance use, mental health, trauma, anything, let me know what you'd like.
So Katie, I would also look at you to maybe look at also what you're using and what you're assessing in some of your decision making too, because you may not get exactly input from these other six. Sometimes they might give you a little, they might not, but also
Trying to
what are
say.
you seeing and what are you using? What do you think would be, what do you think would be helpful too?
That's really hard because I think you even can tell from my questioning sometimes that I just can't kind of, as much as I want to turn that part of my brain off, it's really hard.
Okay. So I'll give you a couple real quick. Substance Abuse 101, the basics of
Okay.
addiction, like just the basics, and
Mhm.
maybe a little bit of mental health. What are some of those key words, some of those acronyms that people might be hearing? What are some of those diagnoses? Just some key pieces.
So the only thing I comment on too, Katie,
That's
is
true.
I think the more we know about that particular issue, it helps us make decisions in a better format. But I don't think it's important to go into a lengthy
No.
cross-examination of a person's treatment program at that point, knowing that they need it. And that's, how you draw the line there between
Yeah.
treating somebody and just from your parole board experience, helping you make a decision as to whether to grant parole and then what conditions are important to set if we do
Right.
or deny.
Yeah.
And understanding both of those diseases, their
Mhm.
mental health issues and their substance issues, and making that decision.
Yeah, the basics.
But not for
Yeah, I
us to go
think-
into detail about what their treatment program involves and whether they should be in it for 6 months or a year or 2 days or whatever.
Yeah.
That's beyond our scope, I think.
Yeah. Well, I think where it becomes really tough for me is like when I hear them saying specific mental health conditions or things like that, and they haven't, and I know what that entails, but yet there's not anything or not enough. That sort of that can sometimes make me want to question like what could happen because I know what could happen. And what's really needed. So that's when it gets a little murky for me, I think.
Yeah, it's tricky.
Yeah.
And I
For
wouldn't
sure.
want to go down those roads. I don't think it's to get that far. It's more of just the basics.
Yeah. And it's, I think where some of the knowledge that I think would be helpful for everyone too is things that might not be so much aware of. It's like if someone says they're on the MAP program, but they only have a cocaine addiction.
Yeah.
Yeah.
Like that doesn't make sense. Like why
That's
are
helpful because the MAP
Yeah.
program's not helping.
I kind of
Yeah.
like alcoholics that are on the MAP program.
Yeah.
Yeah.
So
Because there's certain
Really?
Absolutely.
Yeah.
there's certain things that MAP programs will treat and some that it won't, so
Something like that would be really helpful.
Yeah, basics like that kind of thing.
and the differences between what a methadone treatment looks like compared to a Suboxone and that
Absolutely,
kind
yeah.
of thing.
Yeah.
Different
There
forms
you
of
go.
alcohol treatment and yeah.
There's your subject matter. No, that would be very helpful.
I think another huge thing too that's really important, I think we're definitely hearing a lot of trauma things and people that we see in front of us that have endured significant trauma even from childhood, but just that basic of understanding of how that sort of hardwired their brains differently and why they make and what did that, and necessarily in the offender world, what does that hardwiring mean? What are they more predisposed to in terms of
Sure.
community risk?
Right.
Good point.
Yep. There.
Yeah, those would be helpful.
And we don't have to do them all at one staff meeting either. We can spread it out to whatever.
We'll give you an agenda item.
The latest and greatest in
Great.
mental health
Yeah.
treatment.
Yep. Motion to adjourn?
Motion to adjourn and second, and all in
Aye.
favor signify by saying aye.
Aye.
Already has.
Aye.
Aye.